Good afternoon. May it please the court. I'm Joseph McAfee from Greene County Bar. I represent the appellant, Demarcus Russell. The court, please, I'd like to reserve 5 minutes for rebuttal.
Yes, sir.
All right, having read the briefs, Your Honors, I do not wish to focus too much on the facts, but there are several facts that are worth mentioning that highlight some of the further arguments that I'll be making on the two issues we've raised. On March 5th, 2020, sometime in the evening, the appellant, Mr. Russell, was stopped in Greene County on 11E by Trooper Jeremy Shelton for speeding 72 miles per hour in a 55. According to Trooper Shelton's later testimony at trial, speeding in and of itself is not an indicator of driving under the influence. After Trooper Shelton initiated his blue lights, the appellant reacted appropriately according to the testimony of Trooper Shelton. He slowed his vehicle down. He used his turn signal to move from the fast lane into the slow lane, selected an appropriate area to pull his car over, in fact, bypassing an intersection that would have undoubtedly been an inappropriate place to stop his vehicle, and stopped his car appropriately. And that's according to the testimony of Trooper Shelton. So with regard to the actual operation of the car, Trooper Shelton's testimony was there was no indicators of driving under the influence. So whenever Trooper Shelton approached the vehicle, that's when he began his DUI investigation. He testified he smelled a strong odor of marijuana when he first approached the vehicle. In contacting the appellant, Mr. Russell, he testified later that his eyes were bloodshot. Well, after the field sobriety tests were conducted.
Didn't he also testify that Mr. Russell had admitted to smoking marijuana about 5 minutes before the stop?
He did.
Okay.
And during the field sobriety tests, of course, there were several issues with whether those tests were conducted in a standardized fashion, and I want to be sure to talk about more in detail the issues raised with sufficiency as well as prosecutorial misconduct in arguing the facts of those field sobriety tests. Mr. Russell submitted to a blood draw. The blood draw was submitted to the TBI lab. And according to the testimony of the toxicologist with the TBI, Mr. Russell's blood contained evidence of marijuana use. 10 nanograms were the results in terms of the active marijuana substance, Delta-9, in his blood. Of course, we went to trial, and the jury found Mr. Russell guilty of the 4 counts he was charged with: speeding, no insurance, simple possession of marijuana, and DUI. For purposes of really wanting to focus on our strongest arguments here, we relied mostly on the driving under the influence. So in terms of the sufficiency, of course, Your Honors are familiar with the standard of review there, and Your Honor hit the evidence for conviction here. The smell of marijuana doesn't necessarily mean that Mr. Russell's ability to operate a motor vehicle to the point of not having the same judgment and clearness of mind as the jury instructions say. That doesn't really amount to much there. The bloodshot eyes, well, the trooper testified that doesn't necessarily amount to being impaired. The performance on the field sobriety test, well, let's talk about that for a second. These are supposed to be standardized field sobriety tests. Watching the video, you can tell they were not performed in a standardized manner. There were 2 cars closely together coming down the 11E. They hit the appellant in the side of the face. He turns while he's doing the one-leg stand, knocks him off. He's a little bit unsteady for a second, but the first 10 seconds of that test and the last 10 seconds of that test, he performs well. And with regard to the 9-step walk and turn, the testimony of the trooper, of course, was that he had 5 clues. Okay, well, 2 clues are supposed to indicate that you're at least 0.08 or above, or probable cause in terms of alcohol. There's no alcohol in Mr. Russell's system. There is no standard for determining whether someone is under the influence of marijuana. How many clues does it take to determine, are you under the influence of marijuana? Is it 6? Is it 7? Is it all 8? What does this test mean?
Well, but isn't this a kind of a totality of the circumstances situation? Because you have the smell of marijuana, you have an admission that he smoked marijuana, you have some other indicators during the field sobriety, whether it was standard or not, that would make the officer believe that this person was under the influence. Then you have a blood draw that shows that he has it in his system.
That he has marijuana active marijuana substance in his system. Yes, Your Honor. In terms of the totality of the circumstances, I've never really thought of it that way, but
Well,
in
but
terms
isn't
of
that- but
the
that's what
overall
the-
sufficiency of the evidence.
But that's what the jury's going to look at, the totality of the circumstances when they decide whether or not your client's guilty or not. And wouldn't all these things that we just talked about put together justify a jury finding that your client was under the influence?
Well, in the light most favorable to the state, with all due respect, no.
Well, on the issue of the field sobriety test in particular, I take your point. They're developed perhaps for another purpose entirely. But the field sobriety tests fundamentally are divided attention tasks. And so they're meant to measure whether you can follow instructions, at least in some cases, whether you're steady on your feet, whether you can operate a motor vehicle with divided attention being given among tasks. And so the state says that there were clues of impairment on the walk-in turn, including the wrong number of steps, stepping off the line, not touching heel to toe, raising hands, and doing an improper turn. And so even if that doesn't give rise to impairment, maybe for marijuana purposes, isn't it showing that there is impairment because your client is not able to perform tasks that require divided attention?
It could, but this case is full of coulds and cans, Your Honor.
Well, but our standard of review is that we take the coulds and can'ts in a light most favorable to the state.
Correct.
And so how does the standard of review play in then?
The standard, if that is the only evidence, I would respectfully suggest that is insufficient, that any rational trier of fact, and part of our argument is Mr. Russell didn't get a fair trial. We're not dealing with rational triers of fact. But you look at the results of the field sobriety test, he does pretty well on that one-leg stand. And if you look at the trooper's report, it was made an exhibit at the trial. During cross-examination, the trooper repeatedly agreed that there were no indicators of unusual behavior, stumbling, fumbling, leaning against the vehicle. The demeanor was normal. Impairment, according to the trooper's report, which was prepared later, we don't know exactly when, but upon time to reflect, we'll assume, slight. Wouldn't make a lot of sense to arrest a man for DUI if his mental state was, in terms of impairment, not impaired. That was addressed on cross-examination. So, also, the final point on the sufficiency also is the toxicologist, Mr. Tiller. Let's take his testimony as completely credible. His testimony was that he performed the test and also that that amount of marijuana can cause impairment, could cause impairment. There's no testimony to any degree of expert certainty that under the circumstances that were presented to him, which were very limited, just the blood draw, that the person whose blood this was under the influence of marijuana at the time the blood was drawn, or perhaps looking at the inference going back at the time he was operating the vehicle. He couldn't make that conclusion. He also can't extrapolate. So the totality of the circumstances is a big problem for the state because the operation of the vehicle is lawful and safe and appropriate. So looking at the totality of the circumstances or the evidence in the light most favorable to the state, no rational juror could conclude that Mr. Russell was driving under the influence. And of course, that's under the influence is the issue, the element that we're primarily focusing there for sure. In terms of the prosecutorial misconduct, Mr. Russell's not entitled to a perfect trial, but he's entitled to a fair trial. The evidence in this case is at issue in this appeal, whether it's sufficient as a matter of law. And then we have the prosecutor who is allowed to strike harsh blows, allowed to make strong, impassioned arguments. That's part of what we do. We're supposed to advocate for our clients. But the state has a further duty, which is to do justice and not just win. And that's what happened here. In the opening statement, the state conceded he didn't do bad at all on field sobriety tests. Closing argument, he reiterates, I've seen a lot of people do a lot worse than him, perhaps distancing himself from the case that he's just presented. And then he gives us hypotheticals about what might happen 5 miles down the road, what might happen to you or your grandchild or your child with people riding around smoking dope. Well, what element of the case is he focusing on there? Like what element of the case involves what might happen to somebody's child or grandchild?
But it wasn't the thrust of the argument that you can be guilty of driving under the influence and not be for want of better words, drunk. You know, that you just have to be impaired. And wasn't the point he was trying to make is that, you know, when does that impairment start to become a problem? The fact that maybe you do well on some tests doesn't mean that you're not impaired to drive a motor vehicle. Wasn't that kind of the thrust of the argument, as opposed to just that, you know, he's going to go out and kill your family? Wasn't it more focused on the state has to prove that he was impaired, not that he was drunk or intoxicated?
Your Honor, I mean this respectfully and with no sarcasm. If he had made the argument that you just made, that would have been fine. Of course, that's not what he did. I'll have to assume that he made the argument that he intended to make, which was clearly intended to inflame the prejudices of the jury, talking about yellow lines and white lines and what might happen next time. General deterrence and specific deterrence are things that we talk about in sentencing, not in closing argument. So
Help me with the limiting instruction then. So the court gives a limiting instruction, tells the jury, you know, essentially the arguments here are not evidence, meant to help you understand the evidence. As I understood from your brief, the limiting instruction actually was prejudicial to you, because it helped me understand how it was prejudicial.
Your Honor, I suppose take this in light of fairness to the state. The argument that was first objected to by the state, the objection happened immediately, and that objection, which was, I would say, still timely.
It was overruled, right? Okay.
Was overruled immediately, with no explanation, no admonition to the state. The argument continues for a couple of lines in the transcript. The second objection is made this time with trying to be respectful to the state and fairness to the state. Argument took place at the bench, and well, the judge made no admonition to the state. So reasonably to the jury, it looks like the defense lawyer's whining because he's getting beat, and the judge made no reference to, hey, state, don't do that anymore. Ladies and gentlemen, disregard that inappropriate argument, improper, which it is. So what it looks like to the jury is the defense attorney is whining, and the state is doing nothing wrong, inflaming their passions, talking about what might happen in the community if they let him walk, I guess is the statement. If we look at, what if the defense makes such an argument? If you find him guilty, the Gestapo is going to come to your house and get your children? Isn't that along the same lines? That's inappropriate. But the state did it. So
help me once again, though. At least sometimes we'll take a look at the improper argument in light of the instruction that the trial court has given. And typically this court will say, we assume that the jury follows the instruction that the trial court has given. And so if the trial court says, look, arguments are not evidence, they're meant to help you understand the evidence. Do you take issue with the limiting instruction itself, or is the issue really with how you believe the jury would have perceived you after having two objections without admonition to the state?
I take issue with the limiting instruction itself because it makes no real reference to what just took place. I don't imagine there's an argument or an objection to every closing argument, especially one to prosecutorial misconduct. So rather than necessarily come down particularly hard on the state, the court, in exercising its discretion, should have noted, hey, just disregard that. There should have been an instruction to disregard what that improper argument is, because the jury went back there with an argument from the state, hey, if we let this guy go.
Did you request that the trial court instruct the jury to disregard the improper argument?
I did not, or, well, the defendant did not, but it was noted, overruled immediately with no discussion, and there was no opportunity to suggest to the court perhaps that that would be what should be done. I mean, with the objection being made, the duty is on the trial court to determine what the remedy should be in terms of, that's the State versus Banks case. The trial court, with or without an objection, should take proper curative measures. In other words, the burden's on the trial court to make sure the defendant gets a fair trial. It's my job to try and assist with the defendant with that. So
So you're suggesting that you would have had no duty at all then to, if you thought that the trial court gave an improper instruction, you would have had no duty to raise the issue by way of further objection?
Certainly had a duty to make the objection according to the state of the law, which I'm not entirely sure which case it is, but it is trial court defense counsel's duty to make that objection. He didn't receive a fair trial. We'd like to know what the result would be if he did. Unless y'all have any further questions, that'll be my opening argument.
Good afternoon, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgments of the trial court. And turning first to the sufficiency of the evidence.
General, can I take you to the closing argument real quick?
Yes, Your Honor.
Does the state concede that the argument itself was probably improper, or at least approached the line?
It does approach the line, Your Honor. I will candidly admit that this is not a perfect argument.
The state's argument, as I understand it, then relies heavily upon the limiting instruction.
That is part of it, Your Honor.
Okay. And how else then, how else does the state then maintain that the argument itself, if it were error, did not affect the outcome of the trial?
If the argument were error, it did not affect the outcome of the trial because of that limiting instruction, but also because of the overwhelming proof of the defendant's guilt. There was more than enough evidence for the jury to find that he was impaired under the influence of marijuana. And so these isolated comments from the prosecutor are not what resulted in the verdict here. It was the overwhelming evidence. And then you also had the trial court telling the jury that it was to decide the case based solely on the evidence that was presented.
But just so I'm hearing you correctly, you're not conceding here today that this argument was improper, is that correct?
Not that it was improper, no, Your Honor, but just acknowledging that this was not the most perfect closing argument. I do think what the prosecutor was trying to do was, it just goes to Judge Campbell, what you were pointing out, that the prosecutor was trying to argue that you can still be impaired and under the influence of marijuana without appearing to be falling down drunk.
Sure, and I believe as Mr. McAfee said, the prosecutor could have said that. Instead, the prosecutor said, jury, this could be you, this could be your grandchild, this could be your kid in the other lane. Is the state of Tennessee taking the position here today that that's proper argument from a state prosecutor?
Under the facts of this case, like, it's a very factually specific determination. We have argued that was not error, but I do understand the court's concern with the argument. And I would just again go back to, if there was error here, it was harmless. And we look again to the strength of the state's case, which we had ample proof that the defendant was under the influence of marijuana to the degree that it impaired his ability to safely operate his vehicle.
It seems like the state's position there hinges greatly on the results on the field sobriety test. Is that fair?
It's not just the field sobriety test, Your Honor. It starts with the trooper's testimony that he smelled a strong odor of marijuana coming from the defendant's car when he approached. The defendant's eyes were bloodshot, and the defendant admitted to smoking marijuana several minutes before the stop.
Sure. With respect to the issue of impairment, I mean, it seems like the state's argument relies heavily upon the field sobriety tests.
That is a part of it, but it's, again, as Judge Campbell, you pointed out, a totality of the circumstances consideration. And here, the totality of the circumstances, one aspect of it is the field sobriety test, but it's not the end-all, be-all. We again consider the defendant's own statements, the trooper's observations, the testimony from the toxicologist as well, that the defendant had THC in his bloodstream, that it was a level that indicated the defendant could be impaired. And the toxicologist also said someone could feel the effects of marijuana 2 to 10 minutes after smoking it. And the defendant here admitted that he'd smoked at least 5 minutes before the officer initiated the traffic stop. So again, we take all of these things together, And that shows that any error in the prosecution's closing argument was harmless, but it also shows that the evidence is more than sufficient to sustain the conviction for driving under the influence.
Maybe I can rephrase Judge Greenholz's question.
Would you please?
If you take the field sobriety test out of the proof, would there be sufficient proof of impairment in this case?
Yes, Your Honor, I believe there would.
Okay, how so? I think that is actually what I'm trying to narrow. How would it be? Because at that point, you have a substance in the blood, right? But the substance itself is not the equivalent of impairment. We agree with that, right?
Yes, Your Honor.
All right. So
Nor
we need,
the odor.
Yes.
right. So now, without the field sobriety test, what we have are the testimony of the toxicologist who said that the level may produce impairment, along with an opinion that you begin to feel the effects of marijuana 2 to 10 minutes after, and the defendant's admission that he had smoked 5 minutes previously. Is there any other evidence of impairment apart from the presence of the substance in his system?
Yes, Your Honor, I think, and again, it's not by itself, but the odor of marijuana is something to at least consider. And I also apologize, I misunderstood your question the first time around, so thank you for clarifying it for me.
Judge Hickson asks much better questions. I mean, once again, though, and not to, just to push back gently on this, the smell of marijuana is indicating the presence of marijuana, but the smell itself doesn't indicate impairment, does it?
The smell itself alone does not indicate impairment, no, Your Honor.
So we know that there's marijuana there because we have an admission, we have the smell, and we have the toxicology report. I think what I'm trying to focus in on is what is the evidence of impairment then? And so it sounds to me like it's the toxicologist's maybe equivocal opinion, along with the time, and then the field sobriety test, but it's really the field sobriety test. Is that it?
Yes, Your Honor, that I would agree that the field sobriety tests are fairly key to establishing that the defendant was impaired.
Okay, so your friend on the other side then says field sobriety tests then are developed and designed to detect alcohol impairment. How did the field sobriety test then here help with impairment with marijuana?
Well, I think it goes back to actually a question that you asked, Your Honor, that they're divided attention tests. They're tests that are supposed to measure whether you can complete a task while having your attention directed elsewhere. And these sobriety tests showed that the defendant could not do that, that he indicated there were multiple indicators of impairment for each of the tests that he took. And one of the tests, it was the lack of convergence test, was specifically tailored to discover whether a person was impaired under marijuana. And what's significant about these field sobriety tests, they were recorded. The jury was able to watch this video for themselves, and they were able to hear the defendant's claim that a car driving by caused him to stumble during the one-leg stand. And then they were also able to hear the trooper's testimony about the mistakes he made during the test and view the test themselves to decide whether they indicated that the defendant was impaired. And the verdict shows that having watched these videos, they did believe and reasonably concluded that they showed that the defendant was impaired.
Is the proof from those so overwhelming, though, as you describe it, that of course the jury was going to convict here regardless of any inflammatory arguments made by the prosecutor? Closing.
I don't
Is
think
that overwhelming in this instance?
I don't think just the field sobriety tests themselves would have been overwhelming, because I think there was some debate about how he performed on the test, but the jury was able to look at it and see multiple mistakes. But that's where, again, I think we get the overwhelming proof from the smell of marijuana, the bloodshot eyes, the toxicology report and results, and then the testimony from the toxicology expert about how quickly someone could be impaired under the influence of marijuana. And that, coupled with the field sobriety test, I think, yes, Your Honor, shows overwhelming proof that the only thing the jury was going to do here was to convict, and that the prosecutor's closing argument did not obtain that verdict. It was the proof that was presented. that resulted in that
What
verdict.
do you make of the prosecutor's argument, though, that the field sobriety tests themselves may have not been especially powerful evidence? If the prosecutor gets up and says, hey, he did okay, I've seen a whole lot worse in this court, as it goes, it seems like the prosecutor himself is diminishing the impact of the field sobriety tests. And so then if that's removed from the equation, largely so, then we're just left with the toxicologist, right? And so is that overwhelming?
I don't think the prosecutor was trying to necessarily remove the field sobriety tests. I think he was trying to tell the jury that, again, this may not be a case where the defendant appears falling down intoxicated, but that doesn't mean that he was not impaired. I think that's what the prosecutor was trying to do, and so he didn't tell the jury to completely disregard the field sobriety test. And I think those are an important thing for the jury to have considered.
But if the FSTs are the only real proof of impairment in this case, doesn't that highlight the defendant's point here that this was not a slam dunk case, and therefore any statements made by the prosecutor in closing definitely could have swayed it in favor of the state?
Well, Your Honor, I do think, though, that the field sobriety tests were not the only evidence of impairment.
I shouldn't phrase it that way, but in light of the discussion that we've had, you have all of these other pieces of evidence that by themselves are not indicative of impairment. But to actually show that those substances in the defendant's body were impairing him and affecting his driving ability, it seems like the field sobriety tests are the only proof in the record. You don't have poor driving, you don't have unsteady walking, you don't have poor speech, things that you generally see in DUI type cases. When it comes to impairment, not just presence of drugs, but impairment, it seems like the field sobriety tests are the only proof in the record. And that was the point I was making with that.
Yes, Your Honor. No, I apologize. I see what you were saying, and I would agree to the extent that the field sobriety tests are very significant, but I think the testimony from the toxicology expert is something that established that the defendant was impaired. He explained how once you smoke once THC is ingested into the bloodstream, it can impact someone within 2 to 10 minutes, and then he explained how it would be difficult for someone to maintain their attention and focus on the road.
I want to circle back to the question I asked earlier about this closing argument, and I want to make sure I heard you correctly. I think you might have said there were other cases where that type of argument has been employed. Are you referring to decisions of this court that have approved argument like that, or are you talking about other cases that your office has argued and advocated that an argument such as that was acceptable?
What I was trying to say, Your Honor, was just that in this very specific, there have been other instances where this court has concluded that arguments like this were improper. What I was trying to say is that based on sort of the unique facts of this case, this is one instance where that level of argument may not rise to the level of being error, certainly not reversible error.
What specifically about this case would make it okay for the prosecutor I don't want to say insinuate, that's almost too light of a word, but to have the jurors place themselves or their family members on the same road as the defendant on that evening? What about this case makes that acceptable?
In this case, it's the testimony of the toxicology expert who gave a lot of lengthy explanations as to how someone's attention could be compromised if they were driving while under the influence of marijuana.
Why couldn't the prosecutor just say, well, look, this is how it could affect other motorists on the road, versus saying, this is how it could affect you if you were driving, your child, your grandchild? Why is that acceptable in this case from the state's perspective?
Because what this court has said, and it was in State versus Gann, that a prosecutor can, while not pointing out the consequences of an acquittal, can highlight the danger of a particular offense to the jury. And I think that's what the prosecutor was trying to do here, but I do acknowledge there are certainly some problems with the closing argument, and that's where I would just go back to, if there was error here, it was harmless based on the totality of the
But
state's.
you're not conceding that this argument's improper, just so we're still on the same page, is that correct?
Not conceding that it is improper, but recognizing that's certainly a possibility at least, and alternatively asking this court to find that if it was improper, that any error was harmless. And unless there are any further questions, we would ask this court to affirm the judgment of the trial court. Thank you.
All right, thank you, Your Honors. With regard to the rebuttal of the state's argument and the sufficiency of the evidence, I would point to a couple of things. First, the divided attention task, the field sobriety test. In questioning those even further, if I can't recall exactly which page it is on the transcript, but at some point during cross-examination, defense counsel asked the officer what day his 31st birthday was. We were talking about something completely different, changed the subject. It clearly threw him off. He couldn't say what day his 31st birthday was. Of course, his birthday is the same day every year, but the exact day of his 31st birthday divided his attention. He couldn't answer the question. He never did. It's safe to assume Trooper Shelton, upstanding officer, was not under the influence while he was testifying at this trial. So divided attention tasks can cause even people who are not impaired to the point of meeting the element of being under the influence to have some trouble. So further in discussion of Mr. Tiller's testimony, the blood alcohol versus the blood THC, I suppose. In his testimony, he stated that when we look at blood alcohol results from a toxicology test that he might perform, the presence of blood, the presence of alcohol in someone's blood has a correlation to the amount of alcohol that may be affecting someone's brain, the alcohol in the brain. He could not make that conclusion with regard to the amount of THC in one's blood and the effect it may have on someone's brain. Too many factors are in play. The frequency of use, the age and weight perhaps, I can't remember specifically if he said age. So there are too many moving parts here for Mr. Tiller's testimony to have a lot of weight sufficient to support a conviction for driving under the influence. He never said, I can state to this degree of certainty this person was under the influence. All he had was the blood sample. He said it could have caused this person to be impaired. So with regard to the prosecutorial misconduct argument, we look at, I believe it's the Gilbert case that is either cited in the defendant's brief or perhaps just the state's brief. In that particular opinion, I think it was the Court of Criminal Appeals that said this argument that the state made was inappropriate. That there was one instance in that closing argument, and the proof in that case was night and day infinitely stronger than in this case. Here we have two instances of inappropriate arguments, both of which were objected to, and the proof in this case is objectionably questionable. This is not, as the court has mentioned, this is not the case where the person's stumbling around and having problems actually operating the vehicle. Perhaps there's hopefully not been a traffic accident where the person is covered with the smell of alcohol. Completely different case than this. This is where the field sobriety test, the blood test showing the THC in the person's blood, and the person's operation of the vehicle, which you can clearly see on the video from the stop, is perfect. So certainly a question as to the sufficiency of the evidence. And so looking at one of the factors, I believe, under the Buck case, State versus Buck, and looking at the 5 different factors about how the defendant may have been prejudiced by prosecutorial misconduct, the relative strength of the state's case. Certainly, if this was a case where the evidence was overwhelming, then the prosecutorial misconduct and the argument that's been objected to here today, it would be harmless error. It's not going to make much of a difference in light of all the proof. But here, if there's sufficient evidence as a matter of law according to this court, I would have to submit it's still pretty close. And when we have that case, coupled with the improper arguments of the state, he didn't get a fair trial. And we would ask this court to dismiss the DUI in terms of the sufficiency of the evidence. And if the court doesn't see it in that light, then we would ask that the court grant him a new trial on all counts because he's entitled to a fair trial. Thank you.
Right. Thank you all. And I believe that concludes our docket for today. We're going to recess until tomorrow at 9:30.
All rise.